for that very enlightening, insightful discussion and very incisive questions. This panel deserves another warm round of applause. Can we do that? At this point, I would just like to acknowledge the presence of VP for Legal, Professor Tudor Ote. And second announcement, can I please request everyone to turn off your cell phones because they are affecting the sound system. Thank you. Now, our panel is ready for questions from the audience from UP Diliman. Just one from UP Diliman because we have a lineup of questions from all the other CUs. Since we have very limited time, please keep your questions brief and direct to the point. We will entertain the first question from UP Diliman, College of Law. Please raise your hand, and when recognized, please proceed to the microphone. State your name, your college, or your institutional linkage, and then state your question very briefly and clearly. Can we have the question now? Okay, we have one from the lady in green. Please approach the microphone. We have one there, right there, please.
Good afternoon, sirs, ma'ams. As I see it from the discussions of the three, there's really a conflict. The problem here is that there's a conflict between two disciplines. One is anthropology and the second is law. So because in the realm of anthropology, there's a consensus that there should be no definition of indigenous peoples. However, in law, it's always a rule that there should be a definition of a term because in order for something to be operationalized in law, it should have a legal meaning. So, as I see it, so there's really a conflict. So, my question is, how do you reconcile this problem? Is it possible to determine members of indigenous peoples without defining them in the first place in law?
Okay, can we have, who would like to answer that? Leonen?
I think this is the chance of my students to get back at me, but in any case, well, the conflict has always been there. I think in any kind of in any discipline in the law, there is always the conflict of the administrator, the state, the judiciary, and the legislature trying to find out how it's going to simplify the matter in order that it's administrable and interpretable. So there is always that conflict. Now, of course, when indigenous peoples are not defined, especially in international law, it therefore postpones the definition to the states. And therefore, I think the political agenda there would be to allow indigenous peoples to be able to rally and, well, lobby around their various states. In the Philippines, I think the compromise that was done in 1997 was to try to put in 3 different definitions so that the discretion of the NCIP would not be too wide. You see, at that time, and I think I shared this with a lot of advocates who went through the halls of Congress, lobbied through each member of the House of Representatives and the Senate, we were not really very sure who were going to be appointed as NCIP commissioners. So that therefore, we were trying to find a balance between giving full discretion to an agency given the power to define indigenous peoples, and on the other hand, just simply defining what the law is. What's the proper balance? There is none. There is none because, as you now know from the presentations, that the concept of identity is fluid. It depends on your standpoint, depends on the context, depends on the politics of a given situation. I think the point that is being made right now is that, of course, the balance that was struck in 1997 was wrong. And of course, any balance struck in 1997 will forever be wrong. And the next balance that we are going to strike is also wrong. But at least insofar as whether that provides the platform for more fundamental changes for our peoples, or whether that provides the platform in order for more enclosures, privatization, etc., and all the other things that were mentioned, would be a matter of our sense of what is proper at a given time. Of course, the ultimate challenge is that you have to talk to your legislators, you have to talk to your administrators, and that's a different problem altogether. So what is the proper balance? It depends on the politics that becomes captured in the law.
Okay, thank you very much, Dean Leonen. I think UP Cebu is ready with its question. Can we have Professor Bukoy, please, moderator from UP Cebu?
We have two questions from UP Cebu.
Hello.
Should we not leave to the IPs the prerogative?
Excuse me,
to decide?
Bukoy, we will entertain only one question because there are other questions lined up. So go ahead with your one question, please.
Should we not leave to the IPs the prerogative to define their identities and entitlements?
Okay. Who would like? Prof. Gatmaytan, would you like to answer that, please?
Yes. Definitely, there's no debating that question. The problem is the indigenous peoples are not part of the legislature. No? So, how do you deal with that dynamic? And that is, I think, to go back to the first question, sensitization. Definition is impossible. As Marvic pointed out, it's going to be, every definition you will come up will have its shortcomings. What you can do, I think, is to sensitize you to what identity is. No? Rather than think of it as a permanent tag that people carry around, it might be more productive to talk about sensitizing members of Congress, members of the government, to nuances of how people treat identity, how identity politics in general.
Okay, thank you, Prof. Gatmaytan. UP Manila is ready. Please come in, Dr. Padilla.
Magandang hapon sa ating mga tagapagsalita. Meron kaming isang katanungan dito. Magandang hapon sa ating mga tagapagsalita. Meron kaming isang katanungan mula rito sa UP Manila. Ako nga pala ay si Abe Padilla at magandang hapon sa inyo. Ang katanungan ay 10 taon na daw ang IPRA, pero yung opisina na nangangalaga supposedly sa Indigenous peoples, yung NCIP, ay palipat-lipat ng opisina mula sa Presidente, Office ng President at DNR, DAR. Sa palagay niyo po ba ang jeopardize yung karapatan at saka recognition ng mga katutubo natin dahil sa mga ito?
Okay. Yes, please.
Siyempre, tingin ko talagang, sa akin, ang tingin ko dyan, it's really an evidence of how low the government regards the Office for Indigenous People's Rights and the priority that it gives to this office. Kaya tingin ko, malaking, ang may kagagawa niya, siyempre, ang gobyerno, at dapat singilin sila sa ganyan. Bigyan dapat ang isang body na mag-i-implement ng isang batas ng mas maraming resources at mas malaking power para magawa nila yung kanilang dapat ginagawa at dapat binabantayan naman sila ng mga katutubong mamamayan at saka ng buong Pilipino para magawa nila dapat ang kanilang ginagawa.
Okay, thank you. Yes, please.
There was a test case that was prepared in the city of Baguio against the president and or the entire commission of the NCIP. But it looked like 2 days before the meeting of the lawyers who were supposed to discuss this, the NCIP was returned to the office of the presidency, which is an anomaly because it has always been there. So I don't know why they returned it. And then now they say it's for 6 months again, which means after 6 months, they will transfer it again. Maybe this time without sending the signals beforehand, we will file the case.
Okay, thank you very much, Ms. Corpus and Ms. Pawit. We go to UP Baguio now. UP Baguio, please come in.
We have 3 questions on the floor, but of course you will entertain only one.
Yes,
so may I please let us have Professor Willie Alamgi, Dean of the College of Sciences.
Go ahead, please.
I don't know.
Okay. Good afternoon. Thank you for those very informative inputs. I think part of the problem is that within the current legal framework, there is persistence of a colonialist and paternalistic view that indigenous people are like children who need others to protect them, and who need others to decide what is best for them or for us, because we're also unequal. I think that in the aiming of laws and legal frameworks, indigenous peoples are effectively excluded, and that they are represented by people who claim that they know more about them than they know themselves. So my question is, how can we solve this crisis of representation so that we're able to achieve what Diliman referred to as the multidimensional, multicultural, polyvocal character of indigenous people societies? Is it possible to achieve it within this current legal system, or do we have to put into place structures, parallel structures of governance that indigenous peoples themselves will govern?
Okay. Dean Leonen, I think, is eager to answer. Go ahead, Dean.
It's either, Professor Gatmaitan also mentioned it, it's either you protect property or you protect governance. Protecting property means that you're giving the state the quality of a leviathan, the monster, the capability to be able to enforce rights simply because you've defined what the essential characteristics of those property rights are. You cannot give discretion to the administrator when you recognize property. The Indigenous Peoples' Rights Act in 1988 just simply wanted a declaration that ancestral domains are not public. But then as it went through the House of Representatives and the Senate, the senators and the legislators wanted to make it a Magna Carta for indigenous peoples. Therefore, there are words there to the effect of self-governance, etc. The other approach would be to forget defining property rights from the state perspective, but to allow local constituent political units, whether from the level of an autonomous region, such as how it was won in the 1987 Constitution, or in a local barangay or a local ili in the Cordilleras, to define what their property rights are, and therefore just simply defining a system of governance. In such a case, of course, the theory is that because the local government is closer to the people that it is governing, that sometimes the interests of those people will actually come out in ordinances or legislation. However, on the other hand, local elites are stronger whenever you empower them with more law. So, of course, that is the other side of the debate. So, of course, where we find draw the line is a question that's often addressed to us. That's why some would want to go for charter change. Some would want to review the law on local autonomy, the local government code. Some would like to take a look again at IPRA. Some would want to take a look at other things with respect to the law. The other thing about the law, it will never find the final solution, and there is always that character of legalism, as Mr. Duncan Kennedy mentions. You simplify with the law so that a judge will say yes or no. You simplify with words that are found in the law, and therefore the limits of interpretation would only be the limits of the text of that law. Of course, now many of us are starting to realize that text is open textured. But then given, of course, the decisions that come before it, there are always limits there. So what do you try to do? You try to achieve one thing at a time, but what you want to achieve at present should be something that can give a foundation for the future.
Thank you, Dean. I think Ms. Vicky Corpus would like to add something.
Yeah, very briefly. I think there also needs to be a respect of customary law. I think we cannot just depend on modern law, and that's precisely what indigenous peoples have been fighting for, that we do have customary law, which defines how we can also, our own land tenure systems. And I give an example. For instance, in Bisao and Sagada, we agreed not to delineate our lands into ancestral domains, because the moment we do that, we will have more conflicts between ourselves. So we said, no, we don't like ancestral domain delineation. Maintain it as it is, and we are in peace. We can continue doing